I have the copy of the original constitution. It was passed in 1949, 26.
Right.
I have that. What was the situation at that point of time? One. And number two, 1954.
Right.
When that first order came.
The first order.
There were two before, 1950 and 1952. Both
Yes.
were superseded by 1954. I'll take a lordship clause by clause that what was contained in that 54 order and as well as what was contained in the original constitution when it was passed. We need to go back in time. Without that, it's not possible to apply certain standards as we understand in 2023. This is the situation which has its roots in history. And we have to know why, how and why of if we need to recognize and appreciate how and why of Article 370. Why 370 in the first place? Simply it's a historical process, or there were certain compulsions, there were certain constitutional issues involved, because these were between the two states. It was in the nature of an act of state. Why this Article 370? The Lordship needs to understand this Article 370. It is source. And then sort of a, if I am to say so, sort of a compromise. On the one hand, you said there is no merger, it's not completely integrated. This is one aspect of the matter. The other aspect of the matter is pending as it is. Third aspect is that between the two governments found, okay, you stay with us. You stay with us, but we'll grant you some autonomy. And these are all provisions related to this autonomy. Of course, in terms of 54 constitutional application orders which have been passed, right after 1957 till the last one, 2019, gradually the government of the state has been, if I use that expression, chipping the power of the state legislature. Now, what does it mean when I'm saying so? My legislature in 1950 had the total power of making laws except three subjects. So I could make law on any subject, whatever I liked, because that's the power vested in me in 1950. But what happened subsequent to Article 370? The state government is given the power under 370. Look here, you can concur with the Union of India and request them, please apply this entry. So far, oh, good. When you apply that entry, what are you doing and who is doing it? It is the government of the state which is doing it and taking away the power of the legislature of the state to legislate. Otherwise, that power was with me.
But Mr. Shah, all that must have been done with either the consultation or with the concurrence of the state legislature or state government. No, all this must have been done either in consultation with the state government or in concurrence with the state government.
I'm saying so. I said it resulted in, that's what I'm saying so. 54 constitutional orders which were issued, they were done in concurrence, in consultation with the government. The other flip side of it is that our state legislature continuously lost power to legislate on those subjects, wherever they agreed. I'm not sure the question of wisdom, why they agreed or why they didn't. I remember, just suppose what is left in Article 370, you have gradually donated all the power to the Union of India. That aspect is there. But I'm saying in the original intention, what was the original intention of the constitution makers?
So could it not be gathered from
original intention?
Could it not be gathered from sub-article 3?
3.
Yeah. That the constitution makers.
Notwithstanding that one?
Yes, sub-article 3 of 370.
3 of the constitution.
That the constitution, that the framers of the constitution themselves at that stage conceptualized that at one day the provisions of
that subclause 3 envisages by a process in a given situation that Article 370 would be de-operationalized, to use your phrase.
Yes.
The process is a separate thing. Therefore, to say that 370 has such a permanent character in the Constitution that it can never be amended would be, it's a very, very difficult proposition. Because suppose the state itself had said, that's why to Mr. Sibal also I posed the question.
Yes.
Suppose the state itself says that we want all laws to apply, then where does 370 go, apart from the chipping issue which has occurred over a period of time?
So
then we will really come back to the process. Was this the process permissible or not? That would be the question. That's how I look at it.
Yeah. We might have different perceptions of it, but let me share my perception with the lordships. If we don't want Article 370, answer to this question will first depend on, as on today, on 5th of August 2019, was it still temporary, or because of the passage of time, non-availability of the machinery originally contemplated by Article 370, had it become, despite being in Part 21, showing temporary, marginal load showing temporary, it had become permanent. Permanent in the sense because the machinery was not available to remove it. Now, I'll just I'll clear it more.
Testing this proposition, Mr. Shah. Suppose that machinery was to be created, can it be removed? Is your argument that it? See, when you say it has acquired a permanent character, if the machinery, which according to you is the appropriate machinery, and which did not exist for 370 to be available.
Yes.
If that machinery was to be recreated or created or in existence, then 370 could be removed.
If that machinery was recreated, that is Constituent Assembly recreated. But which Constituent Assembly? Police here, subsection 2. Just for I am aware of a lot of observations my lords are making. Police seat as subsection 2. And I would seek your lordship's consideration also on that. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in the second provisional subclause D of that clause be given before the Constituent Assembly for the purpose of framing the Constitution. So it is identifying which Constituent Assembly they are talking of. And please go back to subclause 3. Notwithstanding anything contained in the foregoing part of this article, the President may by public note declare that this article ceases to be operative or shall be operative only with such exceptions and modifications and from provided that the recommendation of the Constituent Assembly of the state referred to in clause 2. Referred to in clause 2. Today, if your lordship were to direct a you form a Constituent Assembly, my submission would be
a little different. I am saying, suppose as COs have been issued from time to time, and according to you, by concurrence of the state government or the assembly, were there an assembly, was there a state government which says that all the provisions of the constitution will apply? What would be the scenario?
When our state government says all the provisions of the constitution will apply, they will say so how? Outside 370 or within 370. They have to say so that only through 370.
Right.
That is the route.
That's the route. So therefore, once they are able to say so under 370, except that 370 remains in form.
Yeah, then it remains a form. It remains a skeleton. Very true.
It's just a shell.
But the root is one. What's important is root is one. So if you take away 370, let us take away 370.
Even now, in a sense, 370 is not removed in that sense. What has happened is that whatever remained of 370 inside, in their wisdom or lack of it, whichever way you may put it, they've utilized the machinery of 370 to remove whatever was left in 370. That is what has happened.
Kindly appreciate. First of all, who can remove 370 is one question. The lord's observation is that if the government of the state.
The process we have not come to. Process separate. You have an argument on that look, this is not the process by which it could have been done. That's it.
Now, if you wanted to do it completely, aren't we going back to the original position? If you want to completely integrate, then we have to get rid of 370. We have to get rid of instrument of accession, which said 3, then we have to execute merger agreement. Because I was an independent state. We go back to the roots.
The roots, Mr. Shah, you rightly said over a passage of time, the merger agreement, the 370, there were developments which took place, historical developments. Then after that, 370 came, it was to govern. Then over a period of time, different matters, as you say, chip by chip, 370 was the effectiveness of 370 in terms of preserving the right in the states to lay down the law was chipped away over a period of time.
Yes.
Something still remained.
Yes.
That something which still remained, they did it by a process of 370. Whether that process was right or process was wrong is the second limb of the argument, that they could not have done this or they could have done this in this manner. So they have also left now still a 370, but effectively making all laws applicable. So my only query is that doesn't it all come down to one thing? Whether the process they followed to do so was flawed.
Leave the process aside for a minute, Lords. I am one of the federating units. I want to be with the Union of India. 370 as it is it in the nature of an obstacle to integrate myself with Union of India? If it's an obstacle, then obviously somebody who thinks that this should not be an obstacle, you must integrate fully like any other state in India. Then he has to first, constitutionally speaking, not politically, he has to get rid of 370 as it is. That's it one.
Again, this goes contrary. Mr. Gopal Soman's article argument was, this is a medium of interaction, 370. It's a medium of interaction. Therefore, that's the process you must follow. Now, if we go back historically to say that it has to be abrogated, we must go back to the original, then how does it merge with it? The only thing is that under 370, which is the medium of communication between the center and state, which was established, we established a methodology by which slowly, if you wanted, you could do it. Now, once that is there, it has been done. Historically also, if we see, it has been done over a period of time. Something still remained, as I said, at a cost of repetition. Now, that what remained, they took away by a similar kind of a process as what was being done earlier, but the process is said to be flawed because there was no assembly, there was no elected body in picture. That's the only question I had.
Tushar, just one more thing.
Yes.
If one looks at subclause 2.
2, yes.
Now it says that if there is any agreement with regard to subpara 2 to subclause B to clause 1 or in the second proviso to clause D to clause so and so, then the Constituent Assembly will take a call on it. Now the Constitution of India, if one looks at Article 1, which is specifically incorporated in the Constitution of India, it says India, that is Bharat, shall be union of states, states and union territories thereof shall be specified in the first schedule. So the question of merger being complete is absolutely certain. What has been given over here in Article 370 is twofold. One is with regard to the union and the current risks, the right to make laws. They said there could have been even earlier a situation where some articles of the concurrent list or the union list could have fallen in the state list. But in this case, it's case of state of J&K, which is merged with the state of, with the entire country, became part of the Indian Dominion. There are certain rights given to the state legislature to make the laws. That's all.
More rights. More rights.
Yes, more.
In comparison.
Vis-a-vis the list in question, the right to make laws are given to the state legislature.
Yes.
But with one stipulation that the state legislature can, with the concurrence of the state legislature, those laws can, if the concurrence is given, then the central government or the Union of India can also make laws. One. Number two, with regard to the provisions of the Constitution against, with the concurrence of the state in question, gradually the laws can be, all the provisions of the Constitution can be made applicable. That's part one. Part 3, that is clause 3, deals with abrogation of Article 370 or modification or changes in that. Your case, as far as proviso is concerned, what is the effect of the proviso is something separate. Is our understanding correct?
Yes, yes. Yours is correct. The first part is with regard to union list, the making of laws, very true. The state legislature, my state legislature gets more laws. I will show that exactly the same position. It has more laws, more power as compared to in relation to other states in India. And why in relation to other states of India? As I said earlier, I raised one argument yesterday. I said they merged. When they merged, it is the Constitution of India which gave power to these state legislatures. It was open. I would go to the extent of saying it was open for the Union of India not to give any power. It could have made it totally unitary because they had merged. They had no personality of their own. Their statehood was lost with the merger. But government of the Constituent Assembly of India still agreed that under list 2 they will have the powers. That's the theory of separation of powers now, with different views of this honorable court, whether they are administrative in character, whether they are political in character. We're not going to that question. But with regard to Jammu and Kashmir, it was, as I said, concurrence. On my concurrence, he could do that. So I would give concurrence, they would make law. I would give concurrence, they would make law. This position would continue. Under D, Position is the same. I would give concurrence. They would agree for constitutional provisions with or without modification. This power is there.